So tell us, Nishant, one of the first things you do in practice, right, is learn how to draft a plaint, isn't it? Or a
Yes,
written statement,
yes,
depending on whom you're representing.
yes.
So what is your experience like?
Well, it's an art. It's an art which comes after years of drafting. I don't think anybody can really vouch that he's drafted the perfect plaint or the perfect written statement.
Okay.
It's a learning procedure. It's a learning curve. You keep learning all the time. Various lawyers have various styles of drafting. Um, I basically follow a simple procedure that I get all the documents based upon which the case has to be filed from the client, and then eventually, document by document, I narrate a story.
Yeah.
It's more like a story.
So you don't have a template like many big law firms. I mean, I personally have also used a lot of templates myself. Do you have a template that you
I'm
use?
not a template guy,
Yeah.
so I do not have a template.
Yeah.
However, certain planes do require a certain format.
Yeah.
Let's take for an example uh, uh, a matter under Section 138 of the Negotiable Instruments Act.
That's a check box.
Yeah, yes. So then you'll probably like to follow a certain procedure that what all you need to mention: the name of the party, the check,
Yeah.
How much was the amount. And it's a basic structure basically in a
Yeah.
plaint. However, in a commercial matter, for example, if you want to recover somebody some money from the other person, then it could depend upon the various factors that have gone into the transaction and which need to be narrated.
So what about these forms you have at the end of the CPC, right, in the Bear Act itself?
Yes,
Are they actually useful?
I do not. Frankly, I've never followed.
You've never followed
I've never
or
followed
used it, basically.
Never.
Okay. And what about, when you go to court and present the plaint, have you come across instances personally, or have you witnessed judges kind of losing their cool because the plaint isn't drafted properly, or there are arithmetical errors, clerical errors?
It's happened. Though if you talk about typographical errors, arithmetical errors, those can be cured by permission of the court, and those don't sort of annoy the judge that much. However, a badly drafted plaint will definitely annoy a judge.
Okay, when you say badly drafted, you mean the language?
The language, these days, at least at the Delhi High Court, they're very particular about the font you use. Even the Supreme Court.
What is the font?
The font we usually use is Vardhana.
Okay.
With a size 12.
Okay.
And double spaced.
Okay.
And it is very particular that it is double spaced.
Oh.
And
any particular rationale behind the double space rule?
I don't know. I think it's just easier to read. Okay. And probably you can read each line separately, okay, rather than mixing them up.
Have you actually seen judges lose their cool when it's not double spaced, for example?
Usually the registry itself, where you file the documents in the plaint, they themselves reject.
They'll reject it straight away.
Reject it straight
okay.
Yes.
So it's not even going to get to a court judge's desk, basically.
Yes.